Welcome, everyone. I am Mark Miller, the Dean of the University of Arizona James E. Rogers College of Law. I am delighted to welcome you today to a special public enrichment event, one of many we are hosting this year to promote public exchange on matters of public concern. Today's conversation was spearheaded by the University of Arizona American Constitution Society Student Chapter and the James E. Rogers College of Law Enrichment Committee. We also have many co-sponsors, as American Constitution Society U of A President David Herrera will tell you in his introduction. The conversation features the newest, powerful work of Harvard Law professor Michael Klarman, with comment by journalist and Yale Senior Research Professor Linda Greenhouse. Our moderator is Dave Marcus of UCLA, but more importantly, our former Arizona law colleague and truly a forever friend of our college. Dialogues like today's are about democracy and its enduring modern challenges. These conversations are the heartbeat of what all law schools can and should promote. But for a land-grant university like ours, public outreach on issues of democratic engagement are central to our core mission and to our identity. Our thanks to all who made today's event possible, especially the distinguished panelists and our student leaders, again, ably led by ACS President David Herrera. Russ Feingold, the current president of the National American Constitution Society, will now add his welcome to all of you. I now turn the program over to Russ Feingold.
Thank you so much, Dean, and thank you very much to all the attendees. I am Russ Feingold, president of the American Constitution Society, and I certainly want to congratulate the University of Arizona Student Chapter for putting together this terrific program, which I am looking forward to listening to after my remarks. Special thanks to Professor Chris Griffin, Dean Tony Massaro, ACS Student Chapter President David Herrera, Bernadette Wilkinson, Brian Wilson, and the distinguished panelists for their roles in making today's important event possible. The current state of events is hard to sort of capture, but let me just say a few words. Justice Barrett's confirmation on Monday was a dark day for our country. The right delegitimized and damaged the United States Supreme Court, the very body it so desperately seeks to control and use as an instrument of reactionary power. As the court and our democracy enter this new and perilous state, the American Constitution Society, our lawyer members, and especially our law students, will not sit quietly as the right takes away our future. Since the right insists on having a fight about the future of the court, we are here, we are on your side, and we are ready for that fight. The right has essentially captured our courts. There are now as many justices on the Supreme Court who were part of the Republican Bush v. Gore litigation team in 2000 as there are judges nominated by presidents of the party that has won the popular vote in 4 out of the last 5 elections. The lower courts are just as imbalanced. 1 out of every 4 active federal judges is a Trump nominee. Clearly, the right has very big plans for this captive judicial system. Perhaps it will intervene in the upcoming election, as President Trump has openly requested. Perhaps it will strike down the Affordable Care Act in a case to be argued only a week after the election. Or perhaps it will begin a carefully thought out, incremental, but ultimately thorough hollowing out of the last 100 years of progress in American law. But we must not despair. We must and we will respond swiftly and forcefully to make clear to the right that this fantasy of minority rule enforced by captured courts is just that, a fantasy. But this won't be easy. The progressive legal community needs your support today more than ever before. As Abraham Lincoln said, because our case is new, we must think anew. The American Constitution Society and our members are indeed thinking anew and rigorously about how to answer this assault. And we hope that you will support us in this fight. So with that, let me turn it over to a group I'm really interested in hearing from, our distinguished panel. Thanks so much.
Dear friends, welcome. My name is David Herrera, President of the University of Arizona James E. Rogers College of Law, American Constitution Society Student Chapter. Today, we are proud to be joined by the University of Arizona College of Law Enrichment Committee, the American Constitution Society, the American Constitution Society Arizona and Northern Florida Lawyers Chapters, and the co-sponsoring American Constitution Society student chapters from the following universities: Albany Law School, University of Montana, Arizona State University, Columbia, Creighton University, Cumberland School of Law, Florida State, Georgetown, Georgia State, Harvard Law School, Indiana, Loyola Law School, Mercer University, New York University, Seattle University, University of Buffalo, University of California, Irvine, and Los Angeles, University of Colorado, University of La Verne, University of San Francisco, University of Wisconsin, Washington and Lee School of Law, and William and Mary Law School. Professor Klarman of Harvard Law School will discuss today threats to American democracy posed by a range of socio-political developments in our country, the role of the United States Supreme Court in these developments, and how to better protect democracy from these barriers. His remarks are drawn from his powerful new article forthcoming in the Harvard Law Review. Professor Klarman will be joined by Ms. Linda Greenhouse, Pulitzer Prize winner, New York Times Supreme Court reporter, and Yale Senior Research Scholar. The event will be moderated by UCLA law professor David Marcus. Professor Klarman is the Kirkland and Ellis Professor at Harvard Law School. He received his BA and MA from the University of Pennsylvania in 1980, his JD from Stanford in 1983, and his Doctor of Philosophy in Legal History from the University of Oxford, where he was a Marshall Scholar. He is the author of From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality, Brown versus Board of Education and the Civil Rights Movement, Unfinished Business, Racial Equality in American History, and From the Closet to the Altar, Courts, Backlash, and the Struggle for Same-Sex Marriage. Ms. Greenhouse is, as I said before, Senior Research Scholar in Law at Yale Law School. She covered the Supreme Court for the New York Times between 1978 and 2008, and now is a contributing columnist. Ms. Greenhouse has received several major journalism awards during her 40 years career at the New York Times, including, of course, the Pulitzer Prize and the Goldsmith Career Award for Excellence. She is the author of Becoming Justice Blackmun, Before Roe versus Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, the U.S. Supreme Court, A Very Short Introduction, The Burger Court and the Rise of the Judicial Right, and Just a Journalist, Reflections of the Press, Life, and the Spaces Between. David Marcus will be our moderator. A professor of law at UCLA School of Law, Professor Marcus is a much admired and beloved friend of Arizona law. He taught here for over a decade. His publications have appeared or are forthcoming in the Stanford Law Review, the Journal of Law, Economics and Organization, the Texas Law Review, the University of Pennsylvania Law Review, and the Georgetown Law Journal. Welcome back, Professor Marcos. Finally, the formal program will run for about an hour and 50 minutes, after which the panel will respond to a few questions posted, please, in the question and answer section at the bottom of your screen. And also for those who can stay after the end of the formal program, the panel has agreed to stay for 15 more minutes. All audience questions will be curated by University of Arizona Law Professor Christopher Griffin. Thank you for joining us, and bear down.
Okay, well, thank you all. Thanks very much to all of the organizers, and especially to my friend and former colleague, Tony Massaro, for putting together today's event. It's a deep honor to be included. I've been part of a lot of panels and presentations, but none more important than this one. So I want to get right to it. We'll proceed for about an hour before I hand things off to Professor Chris Griffin. I have quite a lot of questions for our very distinguished experts. So I'm going to start with Professor Klarman, whose magisterial article is the inspiration for today's session. I'm hopeful we can get the bare bones of his argument down about threats to American democracy. We'll then spend the balance of our time on the Supreme Court's role in preserving or undermining democratic norms and institutions. There's no one on the planet whose views on this topic are more expert than Linda Greenhouse's. I do have some questions, more in the vein of a devil's advocate, but given time constraints, I'm going to focus at first on eliciting our experts' perspectives, and then I'll press them on some of their arguments if time permits. So let me start with Professor Klarman. Professor Klarman, this session was inspired by your forthcoming article in the Harvard Law Review on threats to American democracy. So I wonder if you could just give us a brief overview with a brief elevator pitch of your argument in that article.
Sure. So let me just start by saying what an extraordinary honor it is to have a panel dedicated to talking about this Harvard Law Review foreword that I wrote. I'm very grateful, especially to Tony, for putting this together. So American democracy, in my view, is under more extreme threat since at any time since the Civil War. There are two basic aspects to this. One, of course, comes from the president, who makes no effort to hide his authoritarian bent. So just very briefly, but I think everyone who follows politics understands what the basic story is. The president attacks freedom of speech in the press. He attacks independent judges. He politicizes the Justice Department. He politicizes the intelligence agency, the Centers for Disease Control, the Food and Drug Administration, the Department of Homeland Security, basically any agency of government that might be personally or politically useful to him. He thinks he has the right to put them to use for his own benefit. In addition, the president has used the federal government literally for his own financial benefit, violating the emoluments clauses probably every day since he's been in office. In addition, the president is an open and notorious racist. He directly encourages political violence. He lies pathologically. He's eviscerated fundamental norms of transparency in government. He manifests a bizarre admiration for foreign autocrats, and he delegitimizes elections and the political opposition, whom he calls traitors and threatens to lock up. Now, if you just step back a minute, I'll talk about the other side of this, which is what the Republican Party's been doing to suppress votes in the states. But if you just think for a minute how extraordinary it is, we have an election next week. The president of the United States is every day demanding that his attorney general prosecute and incarcerate his political adversaries. He's refusing to commit to a peaceful transition of power. He's refusing to firmly condemn white supremacy. And he's actively and persistently undermining the legitimacy of the coming election because he's confident that he will lose it. All of this is straight out of the autocratic playbook used by people like Viktor Orban in Hungary, Recep Erdogan in Turkey, Rodrigo Duterte in the Philippines. And it's worth emphasizing the Republican Party basically takes all of this with barely a whimper of protest. Now, the other part of the degradation, which I think is less well known to people, is what the Republican Party has been doing to undermine democracy at the state level, which is covered in Part 1C of the foreword. And just very briefly, we're talking about voter suppression, purges of the voter rolls, grotesque gerrymandering, like in Senator Feingold's state of Wisconsin, which is probably the most extreme example, delaying and even trying to cancel elections, eviscerating the power of governors when Democrats have won gubernatorial elections, rejecting the results of voter initiatives when Republican legislatures don't like the policies embraced by a majority of voters, such as expanding Medicaid or demanding nonpartisan commissions to draw election district lines, and then perhaps culminating in what we saw again in Senator Feingold's home state of Wisconsin in April, when the Republican legislature literally said to voters, we'd rather that you risk death by showing up in person at the polls than are losing a state Supreme Court seat. Extraordinary when you think about it, and something that's only been going on among the Republican Party for the last 15 or 20 years, and we can talk some later about why that's happening now.
So to follow up on that, so you mentioned, Professor Klarman, you mentioned that a lot of these specific examples are right out of the playbook of the autocratic playbook of the sort that someone like Viktor Orban is following. Can you abstract away from the specifics a little bit and just say what some of these sort of signs of creeping authoritarianism are that we should pay attention to? When I think of threats to democracy, what comes to mind are tanks in the streets and generals and soldiers seizing radio towers and television stations. And that doesn't seem to be what's happening here. So could you just tell us a little bit about what these signs of creeping authoritarianism are? And so we can put all of what you just described into a sort of a larger perspective.
Sure. What you've described is a 20th century picture of the degradation of democracy, and the 21st century picture is very different. So Viktor Orban and Jaroslaw Kaczynski and Recep Erdogan, they come to power through elections. The military coups still happen sometimes in places like Egypt and Thailand, but mostly we're talking about people who come to power through democratic, what they claim are mandates, and then they start using the power of the state to shut down political opposition. They change electoral rules, they take over the media, they try to take over the independent umpires of the system, including institutions of civil society, judges, the intelligence agencies, prosecutors. So again, I give you just an illustration. We've actually progressed further in this direction during the Trump administration than I think even most comparative scholars of democracy degradation believed was likely. So again, never forget the president has refused to commit to a peaceful transfer of power. He said his political opponents should be in jail. He said the only way he can lose the election is if it's stolen from him. His Department of Justice is run by a political lackey who on multiple occasions has interfered with prosecutions of the president's friends and political allies, who's insisted against the findings of his own inspector general that the president's 2016 campaign has been spied on, has parroted the president's baseless attack on mail-in voting. The president has a lackey running the post office into the ground before an election in which more votes are going to be cast by mail than any in American history. The president has a lackey who's now director of national intelligence, who refuses literally to permit the FBI to make reports on white supremacist violence, refuses to testify in person in Congress about Russian threats to the election. We have a president who's urged the Postmaster General to raise Amazon shipping rates because he doesn't like the way that the Washington Post covers his administration. And the Washington Post, of course, is owned by Jeff Bezos, who's the CEO of Amazon. The president threatened to cut off pandemic aid to states whose governors dared to criticize his disastrous performance on the coronavirus. Fox News is essentially a propaganda outfit that makes Trump's presidency possible. It doesn't source its stories. It runs conspiracy theories. It backs up the president no matter what he does. The Republican Party doesn't care that the president tried to shake down the president of Ukraine into digging up dirt on the president's political rival, which is straight out of the autocratic playbook. The Republican Party doesn't care that the president massively obstructed the Russia investigation, doesn't seem to care that the president has blocked efforts to do something about Russian interference in the 2020 election. And then you have, again, what's going on at the state level when Republicans lose the governorship. They decide to try to steal away the powers of the governor, which is again straight out of the autocratic playbook. Scott Walker, the Republican governor of Wisconsin, canceled special elections when he was losing them. Republicans in the Pennsylvania legislature have actively discussed appointing their own electors because mail-in balloting is fraudulent. Republicans have packed state courts in Georgia and Arizona. They tried to do it in North Carolina. Rick Scott said he would do it in Florida if a Democrat won the election. And then finally, what's going on today, again, I think people need to just step back and realize how extraordinary this is. The governor of Texas has said we're going to have one drop box in every Texas county. Harris County is as big as the state of Rhode Island, but they're going to have one drop box because they don't want people to get their absentee ballots in on time. In South Carolina, the Republicans have said they're not going to waive a requirement that when you file an absentee ballot, you have to get signatures, you have to get witnesses, even though during the pandemic, we might say that's contraindicated. In Wisconsin the other day, they refused to extend the counting of mail-in ballots. Again, this will literally cost tens of thousands of people their votes. There's no good reason to do this. We're not talking about extending the voting deadline. We're talking about extending the counting of ballots when the mail-in balloting process is being actively sabotaged by the post office. So again, serious concerns about the degradation of democracy. It's hard to process all this because there's so much going on and every day there's a new outrage. But Freedom House, which is an organization that rates democracies around the world, now has the United States down to 86 compared to Scandinavian countries that are still at 97 or 100. That's all happened in the last 10 years or so, and people just are not paying enough attention to it.
So all this has happened in the last 10 years, but your article also documents the longer term causes of the Republican Party's declining commitment to democratic norms and institutions. So as you write in your article, the frog boils to death 1 second at a time. And I'll suggest that by the frog, you mean American democracy. So it's not all Trump, in other words, that this has been happening over a longer period of time. So what do you identify, and this will be our last question before we turn to the court, what do you identify as the long-term causes of the Republican Party's declining commitment to democracy?
So this is part 2 of the foreword, and to me it was the most interesting part because it gave me a chance to read in a broad literature of political science and history, and I learned a lot about what I didn't understand, which is why are these things happening right now? Specifically, just to latch onto something you said, it's very important to understand that Trump is more a symptom than a cause of the problem. Now, he exacerbates the problem, but the problem is that the Republican Party has basically abandoned its commitment to democracy, and that's what makes Trump's authoritarian bent possible. So there are several different explanations. The basic overarching point is people start to give up on democracy when they think that they're going to lose all the time. That's why white Southerners seceded from the Union in 1860. They saw the election of a Republican president who was committed to party platform to constrain the spread of democracy as the beginning of a future that was not going to look favorably on the institution of slavery. And so they preemptively walked out of the Union before Lincoln was actually able in any concrete way to manifest any actions against slavery, which he insisted, and the Republican Party platform insisted he was not going to take in terms of interfering with slavery in a state. So I talk in part 4 about various different factors. Race is the largest one, religion is another one, what I call the extreme libertarianism or neo-Ayn Randiism of the Republican Party is a third, and growing economic inequality is a fourth, and these all get converted through various aspects of our political system, our political polarization and negative partisanship into what we're seeing in politics today. So with regard to race, here's something that I couldn't have told you 6 months ago, and I'm sure lots of people are not aware. In 1950, the United States was basically 90% white, 10% black, and minuscule percentages of other racial groups. Today, the United States is less than 60% white, and within 20 or 22 years, the United States will be a majority non-white country. Now, for many of us, that is a matter of indifference, but to a large number of Americans, that is of great concern. There's been rising racial resentment, partly in response to vastly increasing birth rates among non-whites, but also in response to very high, by historical standards, immigration, as well as the election in 2008 of the first non-white president. About 30 to 40% of white Americans manifest what political scientists measure and social scientists generally as high levels of racial resentment. That was the main factor in the Republican primaries that predicted votes for Donald Trump. Religion, the United States historically has been a white Christian nation, unofficially a Protestant nation. In the last 30 years, this is happening very quickly. The number of Americans identifying as none of the above, meaning no religious affiliation, has tripled. In the 1950s, overwhelming majority of Americans were white Christians. Everybody went to church pretty frequently. There was no God gap between the parties. That changed dramatically beginning in the 1970s, accelerating under Reagan's presidency and the alliance of the Christian evangelical right, Jerry Falwell and the moral majority with the Republican Party. You saw beginning in the 70s and 80s a big decline in mainline Christianity. And in the last decade, you've seen the same thing for evangelicals. Gay marriage was inconceivable to them. Now you're talking about transgender bathrooms. Their children and grandchildren are leaving their faith, partly because the faith seems to those younger people as so inhospitable to gay equality. The world is getting worse for these people, and that turns out to be the most important predictor of Trump's support. 80% of Trump supporters say the world is getting worse for people like them in the last half century, while 80% of Hillary Clinton supporters say the world is getting better for them. So Trump is their protector. He defends the right to say Merry Christmas. He appoints anti-abortion judges. He changes the rules on transgender military service. He moves the Israeli embassy to Jerusalem. And that's how he wins 81% of the white evangelical vote. With regard to the neo-Ayn Randians or extreme libertarians, these people never really believed in democracy because what matters to them is protecting property rights, and democracy can obviously be a threat. This is what Mike Lee said the other day very explicitly, that the bottom line is we're not after democracy. What we're after is prosperity, peace, and basically the protection of property. Now, these people were marginalized during and after the Depression, but they made a comeback beginning with Barry Goldwater's presidential campaign in 1964, and then the famous memo written by Lewis Powell before he became a justice on the Supreme Court, advocating that the political right needed to fight back, that the colleges and the media, even corporations were just much too cozy with liberalism, and they needed to fight back. And the Koch brothers and various other conservative billionaires started investing in libertarian think tanks, trying to get universities to hire libertarian faculty. And then with politics, Reagan in 1980 kind of converted this into a political cause and famously said in his inaugural address that government is the enemy. Tax cuts became the only reason for existence. Grover Norquist forced all Republicans to take a pledge that they would never raise taxes. What these people care about is deregulation and often environmental degradation. That's what the Koch brothers are investing in. They are fossil fuel extractionists who care only about undermining the ability of the federal government to regulate the environment. These people over the last 4 decades have essentially taken over the Republican Party. When Mitt Romney said in 2012 that the 47% were only interested in getting things from government, not contributing anything and not working, he was mouthing the Ayn Randian approach to the world. Paul Ryan says that free lunches for school children might feed their stomachs, but they destroy their souls. Tom Tillis, the senator of North Carolina, says that as long as restaurants post a notice saying employees are not washing their hands, that should be fine because everybody ought to be able to protect themselves. You don't need to force people. They don't have to eat at the restaurant if they want the employees to wash their hands. The North Dakota governor said the other day that responding to the coronavirus is not the job of government. What is the job of government? Maybe we shouldn't fight fires. Maybe we shouldn't have hurricane relief. Maybe we shouldn't have a police force, right? People can hire their own security guards. So this is the Republican Party, Mitch McConnell, Paul Ryan agenda. They don't care if it's unpopular. The neo-Ayn Randians have never thought that property rights were secure in a democracy. So that's basically the story. I could talk a little bit more about economic inequality, but I've already said enough.
That's great, and I encourage everyone who's joined us today, when Professor Klarman's article comes out, to read it carefully. The overview he's just provided just scratches the surface of an incredibly detailed and persuasive argument. But this seems like a good time to begin to transition to the Supreme Court. So I'd like to bring Linda Greenhouse into the conversation here. I think she's the perfect person to whom to pose the following question. So let's assume that Professor Klarman is right, that the Republican Party has turned against democracy, and that declining white and Christian majorities might explain its anti-democratic turn. So Professor Greenhouse, how might we understand or look at Amy Coney Barrett's nomination through this prism? To what extent do you think her nomination to the court mirrors some of the themes of Professor Klarman's argument?
Oh, it's kind of the apotheosis of those things, really. I mean, I call her the chosen one. This has been building up for a long time. And of course, Republican presidents since mid-century have been extremely lucky. They've gotten the vacancies. They've gotten the opportunity to put people on the Supreme Court. You know, Jimmy Carter, who had the great boon of Congress had given him a great expansion of the federal courts, not the Supreme Court, of course, but the district courts and the courts of appeals. And he really had a great record of putting really very well-credentialed progressive people on the courts, but he never got a chance to fill the Supreme Court vacancy. So of course we have President Trump with his third. And I'll just digress for a minute to say in Mike's long, engrossing article, the sentence that jumped out at me was one that he repeated in his elevator pitch, which is that autocracy doesn't come through military intervention these days. It comes through democracy, through the origins of the organs of democracy. That I just want to underscore, you know, how important that is. So we've gotten the Supreme Court we have through, until these last couple of vacancies, the normal working out of the confirmation process. And, you know, the kind of key moment in 1987, when Ronald Reagan, in the waning days of the Reagan administration, in the 7th year of his 8 years, with the Iran-Contra scandal going on and hearings and everything, nominated Robert Bork to the Supreme Court to fill the vacancy left by the retirement of Justice Lewis Powell, who in his day was the swing justice. He was the median justice of his day. He was the Anthony Kennedy of his day. So it was a very important seat. And what the Reagan administration was trying to do then, because it had lost the Senate, Democrats had taken back the Senate in the 1986 midterms. So the Reagan administration could not achieve through legislation its goals. They thought, well, here's our chance to get the court. And they tried with Robert Bork, and he was rejected by a bipartisan vote. Sufficient number of Republicans came around to oppose the Bork nomination. That was a kind of a reaffirmation of the role of democracy, really, in kind of superintending the Supreme Court, our least democratic branch, our branch of unaccountable, life tenured individuals, some democratic accountability. So who won the Bork battle? That's been a question that's been hanging there for the generation since then. And for a while, it looked like the progressives won the Bork battle because Anthony Kennedy, sitting in the seat that was designated for Robert Bork, voted to preserve the right to abortion, vote the opinion that gave us same-sex marriage. He was no liberal, but he was certainly not Robert Bork. More recently, it seemed that, the Bork forces won. They just had to wait a while. They just had to play the long game. They just had to be very patient. They had to cultivate in the law schools, in academia, in the foundations, the infrastructure, the intellectual infrastructure that they had built. They had to cultivate the justices to be and had to wait for the right political moment. And that brings us Amy Coney Barrett. basically raised, cultivated in a sheltered workshop, right? I mean, look at, you know, I wrote a column last month saying that actually her credentials, although the president introduced her as, you know, the greatest thing since Oliver Wendell Holmes, her credentials are actually very thin. You know, sure, she was first in his class at Notre Dame Law School, and she clerked on the Supreme Court. Okay, good for her. She spent a year or two as a junior associate at a law firm, and then she went back to her alma mater and taught for 18 years in a place where everybody agrees with her, everybody shares her basic beliefs, and you know, I can't, in my decades of watching the Supreme Court, I cannot think of somebody with such a unidimensional background. I mean, even somebody, you know, the leading conservatives on the court, Clarence Thomas, he ran a federal agency. You know, Sam Alito, he was U.S. attorney. He was on a federal appeals court for more than a decade. She got the stamp of approval early in the game, and it's come around for her. And that view Monday night when she and her husband and the president and the first lady stood on what I call the Mussolini balcony of the White House, overlooking, you know, the horde of cheering people. Oh, that was a really creepy sight. We don't do that in this country. We don't have presidents flaunt their Supreme Court nominees in front of a political rally a week from a presidential re-election campaign. We don't do that. I mean, Justice John Paul Stevens, may he rest in peace, believed that justices should never enter the doors of the White House. He refused to go to White House swearings in of those who came after him, even though these were private East Room events. They weren't, you know, before the mob scene on the South Lawn. So we've come to a very different place. And that really was a vision of autocracy come home, that view on the balcony. I'd be interested if it struck Mike the same way, the same jarring way that it struck me, actually.
I have some of the same reaction that it's absolutely inappropriate for the president to be celebrating at a political rally, putting a justice on the court, and that justice won't commit to recusing herself from an election-related controversy that the president has explicitly said he's putting her on the Supreme Court to resolve. I find that very troubling, but everything that President Trump does is very troubling. This is just another quiver in his bow, I suppose.
Professor Greenhouse, I think that your description of Justice Coney Barrett's nomination and now confirmation as the apotheosis of a decades-long game is very powerful, and I think that that's quite right. I agree with it, and I also think that her supporters believe that she will continue, if not accelerate, the ways in which the Supreme Court has aided and abetted the Republican Party's anti-democratic assault. So I want to turn back to Professor Klarman and ask him, in what role has the Supreme Court played in this anti-democratic turn? What are a couple of examples of the court's complicity or it's a couple of examples of the court's contribution to these threats to democracy?
Yeah, I like the word complicity. I'll stick with that. I can understand why you don't want to be committed to that. Let me say a quick word about Bork for the audience, which is mostly too young to remember this. The Republicans feel as if this all started with Bork. They've actually turned the word Bork into a verb, that he was borked. They feel that this was very unfair. I'm not going to get into the details. I just want to very briefly say that here's the Democratic case for why Robert Bork was unfit to be on the Supreme Court. He criticized the 1964 Civil Rights Act when it was being passed as representing a principle of unsurpassed ugliness. He said the 1965 Voting Rights Act was unconstitutional. He said the Constitution does not protect a right to privacy, meaning the state can criminalize the use of contraceptives even by married couples. And it was only during his confirmation hearings that he came around on the idea that women are protected under the Equal Protection Clause. He had said the opposite before. So I just want to make it clear that young people understand that the argument against his being on the Supreme Court is that if you hold those views, you are unfit to be on the United States Supreme Court. And I'm perfectly happy to defend that position. So here's what the court's done in a nutshell. They struck down Section 5 of the Voting Rights Act in 2013, essentially telling us that racism is a thing of the past, which various Southern state legislatures immediately demonstrated that was not true. So let me just say a word about that, and then I'll mention a couple other cases. Within weeks of the Supreme Court's decision in 2013, the North Carolina legislature passed a law that included a strict voter identification requirement for voting that excluded the forms of voting, the forms of identification most likely to be held by persons of color and young people. The legislature had previously not thought there was any need for a voter identification requirement, but African Americans had turned out to vote at higher rates than whites in 2008 and 2012 with Obama on the ballot, and Latino and college student turnout had also increased, thus necessitating clamping down on voter ID requirements. The new law also shortened the early voting period, restricted same-day voter registration, eliminated provisional ballots for people turning up at the wrong precinct on election day, terminated registration for 16 and 17-year-olds, and rescinded automatic restoration of voting rights for individuals convicted of felonies upon completing their criminal sentences. In framing the bill, Republican legislators, according to a subsequent court finding, quote, targeted African Americans with almost surgical precision. In addition, the court has upheld voter ID laws and purges in the name of preventing fraud, which essentially does not exist according to social scientists. The court refused to invalidate gerrymandering, which has become absolutely egregious. I'll give you two examples. In Wisconsin, Democrats won 53% of the popular vote in state legislative elections in 2018. That 53% of the vote won them 36% of state legislative seats. And in North Carolina, after Republicans gerrymandered the congressional districts, Democrats won about 50% of the congressional vote, but won 3 out of 13 congressional seats. It's not all gerrymandering. Some of it is just geographic sorting, which also disadvantages Democrats, but a lot of it is gerrymandering. The justices, in refusing by a 5-4 vote to do anything about gerrymandering, said there was no meaningful standard to measure it against, but that's simply not true. The court, in addition, has gutted the campaign finance system to allow unlimited corporate money in politics and suggested that this is a good thing for democracy. And then in the last 2 months, essentially every form of Republican vote suppression that they've adopted in order to desperately hold on to states like Texas and Georgia. We're talking about limiting drop boxes, not counting late arriving absentee ballots, refusing to waive witness requirements, refusing to waive excuse requirements for absentee ballots. All of this, mind you, in a once in a century public health crisis. Everything the Republican legislatures have done, the Republican judges throughout the country, and now the Republican justices on the Supreme Court have essentially said is fine. They say that on the basis of a principle that you don't interfere with elections, that federal judges shouldn't interfere with elections at the last minute, which is a perfectly fine principle in general, but not a principle that is not subject to exceptions during a once in a century pandemic, and is also based on this incredibly naive assumption that legislatures are simply balancing different factors in deciding what election rules to have, as opposed to Republican legislatures trying everything they can imagine to suppress Democratic turnout. The court's not required to turn a naive eye to this. It's Republican justices basically doing the work of the Republican Party. I know that sounds harsh and maybe it sounds partisan, but I think it's very difficult, if not impossible, to understand what's going on, except at that basic level that Republican justices are fine with Republican politicians trying to suppress higher turnout, which everybody understands will benefit the Democratic Party. Yes, the court is a threat to democracy.
Professor Greenhouse, I wonder if you could comment on what Professor Klarman just said. I used the word complicity, which he agreed with wholeheartedly. So the first question is, do you agree with that the court is a threat to democracy, that by its decisions over the past years or even the past weeks has contributed to an erosion of democratic norms and institutions? And then second, if you do feel that way, do you think the justices are witting or unwitting accomplices in this attack?
Yeah, let me try to address both of those. So I put it in a slightly different way, although I'm quite persuaded of the thesis of the article. But I've written an article myself that was published in the Supreme Court Review a couple of months ago that I called the Supreme Court's challenge to civil society. I didn't say democracy, I said civil society. And what do I mean by that? I meant that the court has converted the First Amendment, for instance. We've all been raised on the notion that, you know, when somebody mentions the First Amendment, we're all supposed to stand up and salute. Speech is a good thing. But in quite recent years, the court has, as Justice Kagan said in dissent, weaponized the First Amendment as a major tool of deregulation. And I see it as a threat to civil society, for example, and the article, Mike's article talks about this. In case 2 terms ago, a case called Janus, the court overturned an earlier decision and said that in public employee unions, employees who don't like the union, who don't want to join the union, they don't have to join the union, but what they can be required to do is pay their fair share of the union dues that goes to representing all members of the bargaining unit, which the union has to do under federal law. They all benefit from the collective bargaining that costs money and leads to a wage package and benefits package and so on. That had been accepted as just kind of the cost of doing business. The court overturned that by a vote of 5-4 and said, oh no, they have a First Amendment right of free association, free speech, not to have to pay a dime. And you know, that really undermines the notion that we're all in this together. We all abide by the laws that apply to all of us. In the area of church and state, the court has so privileged religious claims under both the Free Exercise Clause and a truly dreadful law called the Religious Freedom Restoration Act, which has sort of metastasized far beyond what the liberal coalition, a longer story than we can get into in this session, I thought it was doing when it approved this law. You know, anybody who claims a religious reason for putting their hand up and saying, I choose not to participate, I choose not to follow the law that says that as an employer, I have to include contraception coverage in my employee benefit practice because my religion tells me I don't like birth control. And the court says, okay. And that also is undermining the sense that we are all in one society and we all play by the same rules. So I think it's just it's extremely distressing, and there's no indication that it's going to get any better anytime soon. So you asked me about, is the court knowingly complicit, or they're just kind of driven by their own priors and sense of what's right under the Constitution? Actually, I have kind of a mixed feeling about that. I think more mixed than Professor Klarman's. For instance, he talks about Bush against Gore, the 2000 decision that anointed George Bush as president, and that Justice Kavanaugh, in a concurring opinion just yesterday, went on at great length, really the first time that any Supreme Court justice has felt the desire to remind us about Bush against Gore. His article portrays it as, I think, I'm not being unfair to it, 5 justices who woke up in the morning and said, by God, we're going to do what it takes to make George Bush president. I actually don't think so. I think it was more of an example of, I guess, what social scientists would call motivated reasoning or cultural cognition, where these 5 woke up and said, wow, there's a crisis. You know, we don't know who the president is. It's come down to Florida's 25 electoral votes, and we don't know who's won in Florida. And a case has come to us claiming an equal protection violation in the way the votes are counting. That's within our jurisdiction. we have some obligation to fix this up, and we're going to take that case. Do I think that was the right thing to do? No, but I think it was an understandable thing to do from their point of view. The 4 dissenters, the liberals on the court, said, yeah, there's a crisis. We don't know who the president is. And you know what? Congress 100 years ago passed a law to deal with a problem like this and to take it into Congress. And we're just going to sit back and we're going to let that happen. So, you know, that was one thing. And then I would say this about Citizens United. I have maybe a somewhat contrarian from the ideological side of the street on which I walk view of Citizens United. The law that was struck down at Citizens United, the Bipartisan Campaign Reform Act, BICRA, was actually an accident waiting to happen. I actually believe, as a classic First Amendment person, it went too far. It criminalized putting up certain kinds of political speech, advertising in the period before elections. The court should have and initially undertook to simply deal with that problem. The court, in a truly aggressive move, helped itself to the whole ball of wax and took down the entire campaign finance structure. I think that was a big problem and a big mistake. But the law itself, I thought, was naive and asking for trouble, and you know, push certain buttons that it was not necessary to try to get a handle on campaign finance. So I think, you know, motivation is a tricky thing. I think what matters more is who you put on the court, because we all have our own kind of hardwiring. We can be 2 people standing side by side looking at the same you know, physical manifestation of something and see 2 different pictures. And we now have a court stacked with justices who see things. I think, you know, I'll grant them honesty. I'll grant them, I'm willing to grant them decent intentions, but boy, they've been wrong. I mean, Shelby County, the John Roberts decision that took down the Voting Rights Act, actually, I don't want to digress, but actually did not, as I understand it, invalidate Section 5, which was the pre-clearance section. What it did was something more cynical, actually, because it seemed more modest. Took down Section 4, which was the legislative section that denominated those jurisdictions that would be subject to pre-clearance because they had histories of race discrimination in their handling of elections. And what the court said was, well, Section 4 is outdated because there's been so much progress in some of these covered jurisdictions. And so it violates state sovereignty to hold the states to this 25-year-old formula. And we're going to get rid of that. And Congress, you can fix it. Just come up with a new formula. Well, you know, John Roberts had perfect reason to know that that politically could not happen in 2013 when that decision came down. I think it could happen now. If the Democrats win the White House and get a big enough margin in the Senate and can get rid of the legislative filibuster, what I would say is, job one, bring back the Voting Rights Act. You could do it legislatively. Just get a new formula. And how do you know which are the discriminatory states? Look what they've been doing in the 2020 election cycle. Look at the instances that Professor Klarman listed for us. Look at that and pass a new one. Anyway, that's a long answer to your good question, but you know, it's a very complicated scene and a very troubling one. Not only because they might have bad motives, but because they're people who are hardwired to think the way they're thinking.
So that's a great invitation to think about or to talk about what might happen going forward, what might help fix the problems. But before we do that, Professor Klarman, I just wonder if you could react to Professor Greenhouse's comments. Perhaps justices like Justice O'Connor, Chief Justice Rehnquist, Justice Kennedy, the Bush v. Gore generation, you know, they came up before the full flowering of the conservative legal movement. But the Trump appointees are all products of a much more organized, institutionally supported, and ideologically pure conservative legal movement, especially Justice Coney Barrett. So do you, sort of projecting forward, do you think that there's more to fear from the recent crop of appointees in terms of their wavering commitment to democracy, their preferences for what will advantage Republican Party politics over American democracy. What do you think about what do you prognosticate going forward in terms of motive, intent, and the like?
So I actually agree with most of what Linda said. For the most part, I don't think Republican justices are sitting around strategizing, how can we help the Republican Party? Rather, they just think about the world the same way that Republicans do, because they've been Republicans most of their life. Almost all of them have been involved at some level with Republican politics. So they believe the same things that most Republicans believe, which is voter impersonation fraud is real, which it isn't. Race discrimination is mostly a thing of the past, which it isn't. Corporate speech contributes in a positive way to political dialogue, which it doesn't. Labor unions are monopolists and coercive individual liberty and mostly corrupt, so it's good to crack down on them. I'm just not sure it matters very much given the polarization today and motivated reasoning and the ability to believe whatever facts are convenient. I'm just not sure it really matters whether you think of them as deliberately strategizing to advance the interests of the Republican Party or just happening to believe all the things that Republicans believe, which lead to things like voter suppression and Bush versus Gore. I will say that Justice O'Connor, and Linda certainly knows this, Justice O'Connor, the night of the election, famously said when Al Gore, when the networks erroneously called Florida for Al Gore, this is terrible because it meant her husband explained that she couldn't retire for the next 4 years. The Republican justices thought that the Florida Supreme Court, which consisted of Democrats, was trying to steal the election. Well, that's what most Republicans thought, and that's not what any Democrats thought. So what difference does it really make whether they're strategizing to steal to advantage the Republican Party or whether they just conveniently believe the same things that most Republicans believe? The point about the Voting Rights Act that Linda made, the Supreme Court would strike that down. If you pass the Voting Rights Act with a preclearance requirement, Chief Justice Roberts made it very clear that even though, as Linda said, he was striking down the geographic coverage formula, he also made it very clear that there would be a strong presumption against such an inversion of federalism as the preclearance provision. So part of, and I think we're going to talk about this in the next few minutes, is part of the problem is if Democrats entrench democracy, the Supreme Court might strike it down, and everything else Democrats might do, from climate change to gun control to wealth taxes, could very easily be struck down by a Republican Supreme Court. On your specific question that you ended up with, there won't be mistakes in the future like there were. These many Republican appointees, from Lewis Powell to Justice Blackmun, Justice Stevens, and then O'Connor and Kennedy, are regarded as mistakes by the hardcore right-wing base. There won't be mistakes anymore. These people have been vetted by the Federalist Society. They've been loyal foot soldiers in the Republican Party, right? You couldn't get ahead in the Republican Party if you didn't show up in Florida in 2000 to be part of the Brooks Brother riot or the legal team. John Roberts was there. Brett Kavanaugh was there. That you had to be there. You had to show your loyalty or you wouldn't be rewarded. So of course, these people are going to be doing what they're put there to do. And what they're put there to do, it's really important to emphasize this. The Koch brothers, who are investing hundreds of millions of dollars in every election cycle and tens of millions of dollars in dark money to promote these campaigns on behalf of these Supreme Court justices, they don't care about gay marriage and they don't care about abortion. What they care about is the Chamber of Commerce agenda. That is tort reform, limiting class actions, limiting punitive damages, limiting antitrust laws, going after labor unions, unleashing money in politics. This is the most conservative court in history on those issues, and that's what they're put there to do, and that's what they're going to do because that's what they believe. It's not because they think they owe some loyalty to the Federalist Society. It's because they grew up believing these things. Koch-funded think tanks taught them those things. And the Federalist Society was an effort to insulate them from what was famously called the greenhouse effect, which was the impact of trying to earn a good reputation with Linda Greenhouse, who was the greatest Supreme Court commentator of her era, but was thought to seduce these justices into moving to the left. So that they've been cultivated for decades to prevent that from happening. No, there won't be any mistakes from these people. The only qualification to that is They understand we are about to, knock on wood, take a very significant turn to the left in the next election. Democrats are about 80% likely, 75% likely to control the national government. Chief Justice Roberts is a very savvy political operator, and I'm sure Brett Kavanaugh is as well. They will trim their sails because they don't want to provoke the left into reforming the court, expanding the court. That's why Roberts voted to uphold the ACA. That's why he voted to strike down the census question. That's why he voted to uphold DACA last term. He voted against ideological interest. He is very savvy, and I don't think they will provoke a Democratic administration immediately. What they will do is bide their time, allow Democrats to suffer in the midterm elections, and then their ideological preferences will reassert themselves.
Well, we're now where we absolutely have to talk about the future and what can be done. Having been invited to ask these questions, I want to do so now. What can we do about the threats to American democracy that the Republican Party has fueled, and the court's role in making those threats real? So what can be done about this? And let me preface my question to Professor Greenhouse by just setting as an assumption that Joe Biden wins the presidency and the Democrats retain control of the House and they become the majority party in the Senate. So we all know that that is not a certainty, and I'm not saying this in any way to jinx it. I'm knocking on wood right now, but let's assume that that happens, because if that doesn't happen, they're really contemplating lots of different sorts of changes that just won't be realistic. So with that background assumption, Professor Greenhouse, what do you think should be done about all of this? How can we fix our democracy and the court's role in it?
I think the first thing they obviously have to do is get rid of the legislative filibuster so that they have free rein to do what they think is the right thing to do. I mean, I personally haven't come to rest on court expansion versus, major court restructuring versus court stripping, which is the jargon for taking away jurisdiction from the court over certain things. Term limits, I'm basically in favor of, but that's not going to solve the current problem at all, because you're not going to you can't change the terms of the incumbent justices. And it's the incumbent justices that are the problem. So, forget term limits as an interesting thing to talk about, but it's not going to fix anything. I'm thinking more kind of affirmative legislatively. Congress used to do things, Congress brought us the country we're living in, Medicare, and just list the environmental statutes that have been so undermined by this administration. The civil rights, that you name it. I mean, it used to be a time when Congress actually, got its act together and passed legislation that Democratic, or maybe not always Democratic, presidents signed into law. If you think Roe against Wade is in peril and hanging by a thread, and the red states are doing everything they can, even within the general outlines of Roe and Casey, to destroy the ability of women to exercise their constitutional right to terminate a pregnancy, pass a national reproductive rights statute. If you think the Affordable Care Act is going down the tubes or not good enough, pass Medicare for all. I mean, get out there and do things. And if the court pushes back against some of these initiatives, I mean, the public eventually is going to wake up. The problem is, the Republican base has been awake for a long time, and the Democratic base has been asleep. Look what happened in 2016 with the blockade of the Supreme Court vacancy, and Mitch McConnell not letting President Obama fill it. There was some residual hope that Democratic voters would go to the polls and vote out the senators who were standing in the way of ordinary practice of filling a Supreme Court vacancy, but they didn't. I don't think there was I could be wrong about this, but I don't think there was a single Republican incumbent that lost a seat because voters didn't like the way that senator was handling the Supreme Court vacancy. So, you know, legislature needs to start. We can't, we have to shed the notion that those of us who grew up in the shadow of Brown against Board of Education I grew up with, which is that the court's going to save us. The court's not going to save us. Can we save the court? That's a different question, but we've got to think elsewhere, I think.
Professor Klarman, to ask you a version of the same question and to respond to what Professor Greenhouse just said, and I particularly invite you to comment on some kind of court reform legislation, whether it's court packing or term limits or what have you. I think of Roosevelt's effort to enlarge the court in 1937 as having kind of a mixed legacy. On one hand, it cost him politically dearly. On the other hand, the effort did persuade the conservative justices to retire, allowing him to fill their positions with justices more amenable to the New Deal legislation. I wonder if a newly elected Congress and a President Biden were to pursue some kind of court reform legislation from the get-go, would that interfere with the ability of the Democrats to pursue their more substantive agenda, the sort of agenda that Professor Greenhouse just described? And so what would be the priority in your mind? Would it be addressing the court as a bottleneck to democratic reform? Or do you think that something like court packing would be a politically perilous enterprise to pursue?
So I want to make the case for court expansion, but I also want to respond specifically to what you said. So let me offer a couple responses and then make the case for court reform. Democrats now have a stronger case for expanding the court than FDR. FDR did not have a seat stolen from him. He was simply unhappy, justifiably unhappy, that the court was gutting the New Deal, but he got no appointments during his first term simply because there was no retirement or death. He did not have a seat stolen from him, as Mitch McConnell did to President Obama in 2016. The second point is you obviously need to sell this to the party. There's no point to doing what FDR did, but this was 100 years ago and the Senate and Congress worked very differently. There's no point to just making a proposal and then allowing Democrats to tear themselves apart. If you can't sell it to 50 senators, then there's no point to propose it. So the case needs to be made for why this should happen. The problem with going with a substantive agenda first is simply that the Supreme Court, as I've already mentioned, could strike down all of it. So I think the first thing the Democrats need to do, Norm Ornstein made this case the other day, there are 4 or 5 pieces of legislation. You need to obviously have a massive coronavirus relief bill to get the economy back on track. You need to do something about climate change because this administration's been an environmental holocaust. You need to do something about healthcare expansion. You need to do something about democracy entrenchment. The problem is all of this could be struck down by the Supreme Court. So it may be that in order to do everything else you want to do, you're also going to need to expand the court. So there are 2 sorts of arguments for enlarging the court. And if you just bear with me for a minute, the first argument is actually a response to the main argument against, and then the second is an affirmative case. So the main argument against is easily intuited, which is if Democrats do this, then Republicans will just do it in kind in return, and we'll have an endless retaliation. We'll have a spiral to the bottom, and the court will just grow bigger and bigger and bigger. So there are 3 responses to that, and I'll just say what they are, and then I'll just spend a minute just elaborating on them. Republicans pack the court first. Second, Republicans would pack the court regardless of what Democrats do. And third, if you could entrench democracy, you'll actually produce a new political epoch where the Republican Party will have to reinvent itself, stop assaulting democracy, move to the middle, cease to be an extreme outlier, and maybe at that point will admit that it was wrong to attack democracy and that Democrats needed to restore some political balance by expanding the court. I could even imagine if we reach that point that we just start again with court reform, which would be nonpartisan, and I could explore that as well. So the Republicans started this. What McConnell did in 2016 was unprecedented. He lied and said there was precedent for this, but this has never happened in American history. Obama was entitled to have the Scalia seat. Democrats had not controlled the court in the last 50 years, and they finally had a chance to do it, and it was stolen from them. Second, Republicans will pack the court whether Democrats do it or not, whenever it's seen in their interest to do. So just imagine a hypothetical. There's now going to be a Republican 6-3 majority. Imagine Biden wins. Imagine Democrats take the Senate. Imagine in the spring of 2020, we all have vaccines and it's a beautiful spring day, and Sam Alito and Clarence Thomas decide to take a car ride over to Nationals Park to watch a baseball game, and they're both tragically killed in an auto accident. Democrats will then control the court 5-4, but now imagine Biden loses the presidency in 2024 and the Senate in 2024. Do you think for a second Mitch McConnell will refrain from expanding the size of the court? His hypocrisy in 2020 makes it clear that this is what he said the other day. What we did, we had the power to do. We didn't violate any rules. What we're doing now, we had the power to do. We didn't violate any rules. That's what he'll say in 2024. It doesn't violate a rule to expand the size of the court. The only question is whether the Democrats will play the same sort of hardball. At the state level, in Arizona and Georgia, Republicans have already packed the state Supreme Courts. They tried to do this in North Carolina. Governor Rick Scott said he would do it in Florida if a Democrat succeeded him in office. So it's really important to emphasize, this may be the main point. Democrats, whether they do this or not, Republicans will do it the next time they have an opportunity. This is how Mitch McConnell operates. This is how he ran the filibuster. This is how he obstructed Obama's appointments to federal agencies. This is what Republicans did with threatening to default on the national debt. One thing after another, they play hardball and they suspect that Democrats do not have the guts to respond. The independent case looks like this. Democrats have not controlled the court in the last 50 years. The country has become a center-left country, not a center-right country, and this is the most conservative court in the last 100 years. Democrats, after Tuesday, will very likely have won 7 of the last 8 presidential contests. In 2018, Democrats won 18 million more votes in Senate elections across the country, but that only got them 47 seats in the Senate. All the policies that the Democrats want to initiate, expanded health care, increasing the minimum wage, free college for people who are not affluent, higher taxes on the wealthy, path to citizenship for immigrants, more gun control, all of those are favored by substantial majorities, not slim majorities, substantial majorities, and Democrats can't get them adopted because of Republican obstruction. Democrats currently suffer from structural disadvantages: geographic sorting, gerrymandering, malapportionment of the Senate, and the Electoral College. Even though Democrats have won 7 of the last presidential elections as of November 3rd, 5 justices were put on the court by George W. Bush and Donald Trump, presidents who did not initially enter the White House with even a plurality of the popular vote. 4 of the Republican justices were confirmed by senators who do not represent a majority of the country. Now, you can't fix the Senate and the presidency very directly because you need a constitutional amendment, and a constitutional amendment's impossible when one of the political parties benefits from the status quo. Democrats, of course, need to make new states, DC and Puerto Rico, if they want to be states, but that won't solve the malapportionment of the Senate. It will only ameliorate slightly its political effects. There's nothing in the Constitution about the size of the court. Here's something Democrats can do to fix the systematically anti-majoritarian nature of the system. If they don't do it, they're not going to have another very good opportunity, because the demographics may very well mean that the Democrats will not have realistic chances to hold on to the Senate after 2022 or 2024. And last thing I'll say is, I am not advocating in general that Democrats play the same hardball as Republicans. Republicans suppress votes. That's immoral. That's grotesque. Democrats don't gerrymander, and they shouldn't gerrymander just because Republicans do it. Democrats certainly shouldn't cancel elections just because they think they might lose them, as Republicans have been doing in the last few years. But on this issue, the hardball is actually morally neutral. There's no particular moral argument for a certain size of the Supreme Court. Democrats are being cheated out of democratic outcomes. They need to respond in kind. And you may only have one opportunity to get this right. You can't wait, as Linda said, and see what the court does, because the justices are strategic. They will wait until Democrats lose control of the House or the Senate in 2022, and then their ideological preferences will reassert themselves. So I wish I were wrong about this, and there may be creative ways to force the court's hand rather than expanding the court. For example, pass democracy entrenching legislation, mandate immediate appellate review in the Supreme Court, with an understanding that if you dare to strike this down, we will still have time before the 2020 midterms to expand the court. But I think that's a dangerous game to play in, because collapse for the support for the Biden administration could collapse pretty quickly. Senator McConnell is already trying to engineer it so the economy is going to be in terrible state. That's why he won't support pandemic relief before the election. And once 2022 happens, just like Democrats lost the House in 2010, they could easily lose the House in 2022. And they really might never have another chance to win the Senate after about 2022 and 2024, given demographic trends.
I have many, many more questions, but we've reached our hour. It's 1:15. And so I will now turn things over to Professor Griffin at the University of Arizona. And I believe that he's going to moderate or ask some questions that some of you in the audience have proposed. So let me just quickly say a word of thanks for indulging my questions, Professors Greenhouse and Klarman, and I look forward to hearing your responses to others' questions.
Yes, thank you, Professor Marcus. Thank you, Professor Klarman and Professor Greenhouse, for this very invigorating and informative conversation. A note to the participants, the audience, our panel has agreed to stay on until about 1:45 Arizona time, so for another half an hour. If you do have questions, please do post them in the Q&A function on Zoom. Sticking with, for right now, questions of reform of the court and reform of the mechanisms that produce a court like the one we have as of this week. First, this would be a question for both of you. Is there any sense in trying to reorient what the Supreme Court does? The question asker is posing a premise in which the court does not always resolve cases and controversies as understood under the US Constitution, and instead gets involved in the court ruling on matters of greater social policy. Is there any benefit to trying to reorient the court's focus and to stick, as the question asker says, to cases and controversies?
Well, I don't think there's a dichotomy that's so clear between what's the case and controversy within the meaning of Article 3 and what's the social problem, because, you know, as de Tocqueville noted, you know, everything that's bothering anybody in the United States basically arrives at an endpoint in the format of a lawsuit. So I'm not sure that's quite the way to formulate it. I mean, there are interesting ideas floating around. One would be, for instance, to require that the court, to require any Supreme Court decision invalidating on constitutional grounds of federal statute has to be by a supermajority. Can't just be 5-4. You could probably cobble up a constitutional argument for why Congress doesn't have the power to tell the court that it has to have such a rule. You could get an argument going, but that, you know, that would be one. Another would be, you know, stripping the court of jurisdiction over certain matters that sound like social issues. You know, that was threatened back a few decades ago, you know, strip the court of jurisdiction over prayer in schools, strip the court of jurisdiction over, you know, this, that, and the other thing. Again, you'd run into a constitutional issue, even though Constitution gives Congress the power to define the Supreme Court's jurisdiction to some degree, but Marbury against Madison tells us that that's a limited degree. So, you know, that would be some way of approaching I think, what the questioner has in mind.
Let me add something. So I agree with Linda. I think I understand what the questioner is getting at, which is the Supreme Court simply has too large a role to play in resolving questions of social policy. But cases and controversies, the court is bound by a case and controversy requirement. When the court resolves gay marriage, it's a gay couple wanting to get married. When the court strikes down race-based affirmative action, it's a white person or an Asian person challenging their denial of admission to a university. When the court pronounces on gun control, it's somebody who wants to buy a firearm and isn't allowed to do it. When the court pronounces on abortion, it's a woman who wants to get an abortion and the law doesn't allow it. So what I think you're really after is trying to do away with the court's power to strike down statutes. And I'm actually, this may surprise people, I'm actually fine with that. I'm not sure it makes tremendous sense for a Supreme Court composed of unrepresentative, very indirectly accountable, unelected officials to be making national abortion policy, death penalty policy, campaign finance reform policy, affirmative action policy. That's a very strange system. It's not at all clear the framers wanted that. Countries like Great Britain don't have that. I would distinguish that from the court's role as, enforcing the rule of law. We can't do without the rule of law. The rule of law requires that judges in criminal cases not be supporting the government in its vendetta against political adversaries of the president. The rule of law is critical to capitalism and the enforcement of business agreements and contracts. You do not have to have, as part of the rule of law, a system of judicial review. And for much of our country's history, it was unimaginable that the Supreme Court would be resolving all of these questions of social policy. I'm actually open to having that debate, but I don't think probably that's very politically pragmatic. I don't think most people will think we ought to get rid of judicial review, because they'll always say, well, what about Brown versus Board of Education if you did away with judicial review? On Linda's other points, you could have a rule that required supermajorities to invalidate legislation, but I do think there are two problems with that. One is I'm almost certain the Supreme Court would strike that down, not because it's obviously unconstitutional, but because the justices have the power to decide if it's unconstitutional, and they will resent the idea of trying to order their internal workings. So they'll strike that down. The other thing is, even if they didn't strike it down, they could strategically circumvent it, as I would expect they would, simply by saying, look, we all agree that we ought to operate by simple majority rule, but Congress is requiring us to operate by supermajority. So let's just agree among ourselves, anytime we divide 5 to 4, one of the 4 will switch to the 5, and we'll have created an artificial supermajority. That's essentially what law faculties do when they have debates about appointing someone, and those are often contentious and divisive debates. But then, of course, they agree that after they've decided, they'll create a unanimous decision, because the last thing you want to do is hire someone and then make them aware that it was a divisive appointment. With regard to stripping jurisdiction, it's quite clear that you can take away the Supreme Court's appellate jurisdiction. The problem is that doesn't generally solve the problem, because lower courts are then bound by Supreme Court precedent. So if you said, we're never going to allow the Supreme Court again to strike down campaign finance reform, you then have the courts of appeals as the final arbiters, and they've already been packed by Trump because Mitch McConnell prevented Obama from putting any court of appeals judges on the bench in the last 2 years of his presidency. If you tried to take away all federal court jurisdiction, then federal court scholars would argue about whether that's permissible. I think most of them think that it's not, and it's easy to imagine the Supreme Court striking that down as unconstitutional. Generally, jurisdiction stripping has been avoided because it doesn't really solve the problem. Usually you only think to do it after the Supreme Court has offended you. And once the Supreme Court has offended you, there's a precedent on the books, and that precedent is binding on lower court judges.
Speaking of precedent, there is another question about the role that stare decisis could play, and your predictions for what that role will be under the current court. And the question asker points out that several of the current justices have either spoken out directly against stare decisis or indicated in some of their writings that they would not hold themselves to the court's own precedent if they disagreed with the original decision. is there any hope that we can place in the role of stare decisis at the court? Do you believe that there would be a majority on the current composition of the court to respect certain precedents, and that would be a bulwark against the issues that you have raised in the panel?
I think stare decisis has become a convenient fiction that nominees can trot out during their confirmation hearings. Just look at the last term. So June Medical, the big abortion case, we had Chief Justice Roberts writing the dispositive fifth vote to say, I dissented in Whole Woman's Health. I still believe that was wrongly decided, but for reasons of stare decisis, I'm compelled to strike down this copycat law. But by the way, here's what I think the law of abortion is. And there's raging debate now in the circuits over what is the law of abortion, because of the way, in the name of stare decisis, he muddied it up. Look at the Ramos case last term. That was a case on whether, under the Sixth Amendment, states have to provide unanimous juries to convict somebody of a felony. There was a law in the books that said, no, they don't. And Justice Gorsuch, writing for the majority, said, oh, that old case, that was never any good. And so we don't accord it stare decisis effect. It was just a sport. And, here's what we think now. So I think, nobody looking at even last term's docket can come away thinking that stare decisis means anything if 5 justices want to do something else.
Chris, do you want me to say something, or would you rather just move on to another?
No, I'd love to. Yes, let's hear your thoughts.
Okay, great. So I basically agree with Linda. I just want to frame it by saying this is often what judges and justices will say in response to the charge that what they do is inherently political. They'll say, well, I'm bound by stare decisis. I don't revisit every question from scratch. The important point to note here is that this is entirely manipulable. The Supreme Court is free to overturn its precedents. Lower courts are not. Lower courts are bound by precedent. Sometimes they will creatively try to work their way out of one, and sometimes they'll even anticipate that the Supreme Court might overturn one. But Supreme Court justices are free to overturn precedent. So think of what this means. It means in every case, they have to make a choice. Are we going to respect a precedent, or are we going to overturn it? Now, in the Casey case, the 1992 abortion case, they set out a standard for what factors to consider, but those factors are not very rule-like. They're things like, well, has the precedent proved to be unworkable, or have changes in a parallel area of law somehow overtaken the precedent, or has there been a reliance interest? And those are just not going to constrain justices who have strong opinions about whether a decision was ridiculous when it was first decided. So they strategically respect precedent when they want to look like they're not being very political. But Chief Justice Roberts, who talks about the importance of precedent, was happy to overturn Janus, which Linda mentioned, which was a unanimous decision from 40 years ago. There's no rhyme or reason to this. They overturn precedent when they want. Casey, which stated this formula standard, is totally incoherent, because Casey says we have to respect precedent, but they actually overruled the part of Roe that was the basic trimester framework. So they stuck with the part of Roe they agreed with. They overturned the part they disagreed with. But of course, that says that precedent isn't binding, right? Because if you only stick with precedent when you agree with it, by definition, you're not being bound by the precedent. You would decide the case the same way. So the question everybody cares about is, what are they going to do with Roe? And they will either overturn it or gut it, depending on these strategic calculations, whether it produces too much of a blow to their legitimacy if they flatly overturn it. There's no doubt they will gut it. They will make it dramatically harder, or they will allow, to speak precisely, they will allow states to make it dramatically harder for a woman to get an abortion. They will allow states essentially to close down abortion clinics in places like Louisiana, Texas, and Mississippi, so that poor women won't be able to get abortions unless somebody raises money to send them out of state. Wealthy women will be able to get abortions, which they were also able to get even before Roe versus Wade by, for example, traveling to New York after it liberalized its law, or flying to Sweden before any of the laws in the United States were liberalized. they will overturn Fisher or gut Fisher, right? They will say race-based affirmative action violates a colorblind constitution, and they will either figure out some disingenuous way to distinguish Fisher, or they will flatly overturn it. They will strike down disparate impact tests under federal statutes. They will say that violates a colorblind constitution. If they don't overturn a precedent, they'll just figure out a way to distinguish it. So it's not really that interesting a question whether they're going to overturn the precedents or just gut them of any meaning. You shouldn't doubt for a minute that they will pursue this mission, which is to do what they are ideologically committed to while pretending that it's actually a legally reasoned outcome. I know that sounds very cynical, but I think given that they've divided 5-4 on every conceivable issue today, it's a little hard to think that politics isn't pretty much entirely what's driving this, unless you believe the conservative rhetoric that conservatives follow the law and liberals make it up, which I'm guessing most of the audience isn't inclined to believe, and on its face is absurd.
Some of the other questions I'm going to bind together and combine with a thought that's on my mind. So some of our questioners have raised something that was alluded to earlier in the conversation, which would be term limits on members of the court. There was a pickup on the thread of stripping jurisdiction from the Supreme Court, and you've weighed in either directly or indirectly on both of these. I'd love both of your thoughts on whether there is some, and by the way, another thread was on the Electoral College, but I'm going to focus on, because we've already heard a lot of pessimism over getting an amendment to the Constitution that would get rid of the Electoral College. Focusing on Article 3 and the structure of the federal courts, can you perceive of any reform efforts that will lead to some stable equilibrium down the line? Is there anything that will prevent pervasive, constant fights over the structure of the court and get us to a place where politics may still play a role, but we won't have to continue having these large-scale structural debates?
Well, one thing that comes to my mind, and I'm not sure is directly responsive because it doesn't change the Supreme Court, it changes the confirmation process. If you brought back the filibuster and anchored in a supermajority requirement for confirmation, made it statutory, so the incumbent majority leader couldn't, with a wave of the hand, get rid of it, that would disable the president from going as far to one extreme or the other extreme as possible and still get, squeak through a nominee. So, McConnell got rid of the filibuster in 2017, which enabled Neil Gorsuch to get confirmed, which then enabled Brett Kavanaugh to get confirmed, which then enabled Amy Barrett to get confirmed with, tiny 52-48 majorities. So I think that would, lower the temperature for confirmation. Other countries have this. Germany, which has a very fine constitutional court, has a supermajority requirement, and I think there's a lot to be said for it. Now, who's going to unilaterally disarm? That's the political question. But theoretically, I think this is worth thinking about.
So, Chris, I love the way that you put it. I think there are two different problems here, and I would disaggregate them, but maybe there's a way to package them. So one problem is the immediate dire need to protect democracy. And I'm not sure there's a way to solve that problem other than entrenching democracy. And I think the only way to entrench democracy and make sure the court doesn't strike it down is to fix the court. If you could, and maybe another way of saying this is you need to fix our politics before we can get to a stable equilibrium. Now, it's not inevitable that we'll have the political polarization like we have today. I understand the young people in the audience have only experienced this. In the 1960s, Republicans actually supplied more votes for the 1964 Civil Rights Act than Democrats did. In 1968, 50% of Republicans who voted for Richard Nixon said positive things about Hubert Humphrey, whereas today, 10% of Republicans who voted for Donald Trump said warm and fuzzy things about Hillary Clinton. The two political parties did not see themselves as enemies. They did not regard the opposition as a threat to the republic. There are reasons why that's developed, and it's not inevitable, and maybe we'll fix it. We fixed it after the Civil War, maybe we'll fix it. So in that world, which I think to get to that world, you have to entrench democracy, and I'm not sure you can successfully entrench democracy without expanding the court. In that more rational world, 18-year staggered term limits make all the sense in the world. So this is a proposal that actually, I think two of my students, this was their idea, not mine, I'm not taking credit for it, it's just that they don't get the credit they deserve. They wrote a note in the Virginia Law Review about 15 or 16 years ago that I think was the first to put forward this suggestion. And since then, it's kind of been ripped off by other people. So the idea is 18-year terms that are staggered. So every 2 years, somebody leaves the court. That actually has four advantages. You solve the old age problem, which is we really don't want people who are 90 years old, as much as I love John Paul Stevens, as Linda said, God rest his soul. You really don't want 90-year-olds on the court. Some of them have stuck around to 90, like Oliver Wendell Holmes, and they were really not playing with a full deck by the end of their career. So if you had 18-year terms, they would have to leave at a reasonable period of time, probably when they were in their 70s. It solves the problem of randomness, which is Jimmy Carter gets no appointments in 4-year term and William Howard Taft gets 6 in a 4-year term. That makes no sense. It solves the problem of strategic retirements. Why do the justices get to choose which president replaces them? That's crazy. You should have simply, you get 18 years and then you're gone. And it solves the problem of strategic appointments, which is appointing Amy Barrett when she's 48 years old and will serve at a minimum 3 decades and probably closer to 4 decades. Instead, you could appoint someone like Merrick Garland, who's 65 and might make it to 83 without a problem. So it's a brilliant solution, but I'm not sure it solves the current problem. It probably requires a constitutional amendment, although there's an argument it doesn't, but I think it's a strained argument, and we're not going to get a constitutional amendment anytime soon. And if you agree with me, which lots of people wouldn't, and you think the threat to democracy is dire, immediate, and needs to be resolved, I don't think this gets you there. You know, is there a way to combine the two? Again, if somehow you could negotiate with the Supreme Court, which of course you can't do formally, but maybe you could do informally, if the justices said, we will allow these 4 or 5 major pieces of legislation, expanding healthcare, entrenching democracy, doing something about climate change, doing something about gun violence, if we will allow those things to be enacted, then maybe we could say we don't have to pack the Supreme Court. Rather, we could move to some sensible reform where neither party would be guaranteed control. But right now, the Republicans have a guaranteed majority for at least 15 or 20 years. They don't deserve it. It's a minoritarian control. They did it by stealing a Supreme Court seat. And there's just no way Democrats can rationally allow that by declining to play on this one instance reciprocal hardball. And they're not going to get lots of chances to do it. It's now or never. Do it, or you're going to rue the day that you didn't do it. And I have to say, I know it sounds radical. I would never have dreamed of embracing this 5 years ago, and neither is anybody I know. But I think the Republicans overplayed their hand. The hypocrisy in what they did in the last 2 months has gotten lots of Democratic senators who never would have contemplated this talking about it. So I think there needs to be an aggressive push by progressives to force Biden's administration to take this very seriously. And hopefully it'll happen, but I'm not all that confident.
Thank you. I neglected to mention that, again, 1:30 was the end of the formal presentation, and we have now 6 minutes to handle what I think will be the final question. And before I ask it, again, on behalf of the College of Law here at the University of Arizona, on behalf of the Enrichment Committee from the faculty that I chair, thanks to both of you for your participation. Thanks to Professor Marcus, Mr. Feingold, and Dean Miller, and everybody else who made this possible. So this question comes to us from somebody who self-identifies as a former student of Professor Klarman, who had you for constitutional law. And the question is about the role of law schools in what has been discussed today. What is the function that has been played by law schools, by faculty and others in the rise of the conservative movement that you have described, the one that has produced now at least 3 of the 9 members of the court? The person asking the question has the sense that none of what's being discussed on this panel usually gets to the ears and the minds of first-year students. So what can law schools do in response to this? Taking it out of the hands of Congress and a president for the moment, what are your thoughts on that?
Linda, do you want to say something, or should I go first? What do you prefer?
You're the real live law professor.
Just so everybody, you all are too young, but my father, who would be about 103, learned about the Supreme Court by reading Linda Greenhouse in the New York Times. She is the model for Supreme Court legal correspondence. So Yale University may not want to treat her like a professor, but she knows as much about the Supreme Court as anybody alive. 2 things I want to say about this. I think that law school faculties have an unhealthy reverence for the Supreme Court. If you think about the incentives here, I know to a fact I have colleagues in the legal academy who will not embrace court reform, even though they believe that it's called for, and even though they believe that what the Supreme Court has done is horrendous, because they have conflicting incentives. They may want to argue a case before the Supreme Court. They are part of the Supreme Court bar. They may want their law students to get clerkships. I've said to my students very recently, I've had a pretty good record in the last few years of placing people with Chief Justice Roberts. If he reads the foreword, which I'm sure he won't read, but if he knows about it, he's going to have a very different opinion of me than he had before. But I'm speaking the truth because I think this is really important. And I don't aspire to argue cases in the Supreme Court, and my students will have to live with the possibility that they're not going to get a clerkship with the Chief Justice that they might have gotten if I had maintained my silence. But people who, I see a lot of this, and I think I have colleagues on the Harvard Law School faculty who've seen this just recently, embracing Amy Barrett, celebrating her brilliance, talking about how she should be on the Supreme Court, even though she has extreme right-wing views for a country that's left of center. I think that's very unhealthy. And to the extent law schools have done that, taught us to revere the court, taught us to think the most important thing in the world is preserving the legitimacy of the court, and somehow we shouldn't even weigh that in the contest with preserving democracy. I think that's a bad thing. Now, in fairness, I gave a talk last night to Harvard alumni in the Western states, and there are conservatives in the group, and they were outraged by what I said. And they said, basically, Harvard Law School now is entirely limited to the liberal elite and so forth. I only have 3 or 4 colleagues who I think, out of over 100 people on the faculty, who vote for Republican candidates. And as far as I know, I only have 1 candidate who thinks Donald Trump is doing a good job. Elite law schools are very far to the left politically for very complicated reasons. I don't think the elite law schools are responsible for building the Federalist Society. The Federalist Society was, and there's nothing wrong with this, it was built up in response to the legal liberalism of the Warren Court, and conservative law schools, with the help of people like Scalia and Bork when they were on law school faculties, built a club of conservatives to represent an opposing view. And there's nothing wrong with that. They've just done it brilliantly, and they've gotten a lot of money from the Kochs and other billionaire foundations, and they've created a bench of young, ideologically pure conservatives, and now they're reaping the rewards for that. But to some extent, they just did what the left had done in other areas. I mean, the ACLU had done this for decades, and it's a legal interest. The NAACP did it. The right just learned the lesson that they need to fight back in the same way. And Democrats, the left has not adjusted as quickly. In the last 10 or 15 years, I think the left has understood how dire the situation is. And I don't just mean democracy. I mean the rampant economic inequality that is strangling the country. That's only become something that I think the left has really discovered as a vibrant issue that needs to be tackled in the last 15 or 20 years. Maybe Bernie Sanders understood this before that, but most of us, including myself on the left, did not realize the exigency of the problem until quite recently.
Want me to say something?
Yes, please.
All right, there's a lot of themes floating around here, so I'm just going to pick one that has interested me in these recent weeks with all the talk about what to do about the court. There's an interesting generational divide, I think. I think young people, both our students and young faculty members, are willing to consider and to wish for drastic changes in the way the court works. I think those of us who, as I've said before, kind of grew up in the shadow of the time when, from a progressive point of view, the court was right more often than it's been wrong. And of course, hasn't been true in the last decades. Kind of, we cling to a somewhat romanticized notion of not the court we have, but the court we once had, and maybe in some future fantasy might have again. And so, just speaking for myself, I struggle between two impulses. One is, Mike is right. Court expansion is really probably the only thing that would save us from the court that we now have. On the other hand, my instinct is to say, whoa, so drastic, and it's just, it's a generational thing, and something that I think we ought to acknowledge and talk about across the generations. And of course, that's a reason for the program that we've just spent the last hour and a half on. So, so I thank you for including me, and I wish everybody well in this new Supreme Court world that we have just entered.
Indeed. It is we who are lucky to have had Linda Greenhouse and Michael Klarman with us today. Please do look forward to the final publication of the foreword in this volume of the Harvard Law Review. As always, look forward to Linda's columns in the New York Times and writings elsewhere. And I forgot to thank Dean Tony Massaro for really, again, being the brains and energy behind this event. Thanks to everybody who was here to participate, and have a great rest of the day.